Marlene, stop right there.
Nobody paid me what this work actually costs.
The payee forms, Marlene. Your handwriting's
Nothing there.
Marlene Ashby operated without oversight for nearly 4 years as a court-appointed disability advocate in Mesa, Arizona. 31 disabled adults depended on her to protect their money. Not one person checked.
I gave those people everything. Nobody saw that.
She would never get the chance to explain herself. The federal agents standing in her Mesa office that morning were already carrying photocopies of every annual accounting form she had filed with the Social Security Administration for the previous 4 years. Forms in her own handwriting, listing balances that did not exist for clients who were not allowed to read them. 31 disabled adults, roughly $280,000 in stolen benefits, 51 months in federal prison. The woman they trusted to fight the system had quietly become the system. Quick question before we continue. Have you ever had someone in your family who needed help managing their money? A grandparent, a sibling, an uncle who could not read a bank statement on their own? Tell me in the comments who that person was and how much you trusted whoever was handling things for them. Subscribe if you have not already. This channel covers the people who weaponize that exact kind of trust, and there are far more of them than anyone wants to admit. Marlene Joyce Ashby was born in October of 1970 in Glendale, Arizona. Her father, Raymond, taught shop and wood technology at Apollo High School. Her mother, Deanna, worked part-time at a Bosch's pharmacy on West Northern Avenue. The Ashby family lived in a beige stucco ranch house on a cul-de-sac near 59th Avenue, with a carport that smelled permanently of sawdust and a backyard with a single grapefruit tree. Marlene was the older of 2 children. Her younger brother, Carl, was born in 1973 with Down syndrome, at a time when the standard medical advice in Maricopa County was to place such a child in a state institution and try again. The Ashbys did not. Deanna quit the pharmacy. Raymond took on Saturday work at a hardware store on Glendale Avenue to make up the income. Carl stayed at home. Marlene grew up walking him to the bus stop for the special education program at Sunset Elementary, tying his shoes, reading him the labels on cereal boxes, and learning the precise tone of voice required to keep him calm in the dental chair. She would later tell people, and tell them often, that Carl was the reason she chose her career. By the time she was 16, she had already volunteered at a respite program at the Adventist church across the street, sitting with 3 teenage girls with cerebral palsy on Tuesday evenings so their parents could go grocery shopping in peace. She graduated from Glendale High School in 1988 and enrolled at Mesa Community College that fall, commuting east in a used hatchback. After 2 years of general credits, she transferred to Arizona State University and completed a bachelor's degree in social work in May of 1993. Her senior practicum was at the Maricopa County Department of Developmental Disabilities, where she shadowed a caseworker named Frances Wexler. Wexler later wrote, in a letter of recommendation, that Marlene had an unusual ability to slow down for clients other staff found difficult. She was hired in July of 1993 as a case management aide at the Arizona Department of Economic Security, Division of Developmental Disabilities, at a starting salary of $23,600 a year. Her first assigned territory was a section of Mesa east of Country Club Drive and south of Brown Road, a corridor of mobile home parks and aging apartment complexes where many of her clients had aged out of the foster system with no family willing to claim them. She held that job for 10 years. Performance reviews from her DES file, later subpoenaed by federal investigators, described her variously as consistently meeting expectations, highly organized in documentation, and noted by supervising staff for her willingness to attend hearings on personal time. A 2001 review observed that caseworker Ashby had a particular rapport with nonverbal clients and adults with profound disability, and recommended her for continued field assignment. In 2003, she left state employment for a position as a senior case manager at East Valley Behavioral Health, a nonprofit headquartered on Southern Avenue in Tempe. The salary jump was modest, about $6,000, but the workload was more flexible, and she began picking up outside cases. By 2007, she was attending Social Security hearings, Medicaid appeals, and Maricopa County Superior Court guardianship reviews as an unpaid advocate for clients whose paid caseworkers could not or would not sit in the room with them. Her reputation in the East Valley disability community during those years was specific and well-earned. She was the one who showed up. She was the one who knew the difference between an SSI redetermination and an SSDI continuing disability review. She was the one who would sit through a 4-hour hearing for a 38-year-old man with autism whose own parents had stopped coming a decade earlier. Her younger brother Carl died in December of 2013 of complications from sleep apnea. He was 40 years old. Marlene took 2 weeks of bereavement leave, returned to work, and on the morning of March 4, 2014, filed the Articles of Organization for Ashby Advocacy and Guardianship Services LLC with the Arizona Corporation Commission. The registered address was a small office in a strip plaza on East Main Street in Mesa, between a tax preparer and a nail salon. The state filing fee was $50. She paid it with a personal check. Her first clients came from old DES colleagues who had cases they could no longer absorb in the public system. By the end of 2014, she had 9. By 2017, she had 18. By the spring of 2019, she had 31. The Mesa Chamber of Commerce honored her at a small business luncheon in 2018. The local paper ran a short profile that quoted her saying she had built the firm she wished had existed for her brother. To understand what Marlene Ashby was about to do, the audience needs to understand exactly what a representative payee is, because the people in her care were about to be robbed by the only person the federal government had specifically deputized to protect them. The Social Security Administration pays out billions of dollars every month in disability benefits. Supplemental Security Income, or SSI, goes to adults with disabilities who have limited income and resources. Social Security Disability Insurance, or SSDI, goes to adults whose work history qualifies them for a benefit before they aged out of the workforce due to disability. For most beneficiaries, the check arrives in their own bank account, and they manage it themselves. But for adults who cannot manage their own funds, either because of an intellectual disability, a developmental disability, a severe mental illness, or a degenerative condition, the SSA requires a representative payee. The payee is appointed by the agency through a process called the SSA 11 application. Once approved, that person receives the beneficiary's monthly check directly. The payee is supposed to spend that money on the beneficiary's housing, food, clothing, and medical needs first. Any surplus, what the regulations call the discretionary balance, must be saved for the beneficiary's future use in a dedicated account titled in the beneficiary's name. To make sure none of that money is stolen, the SSA requires every representative payee to file an annual accounting form. The form is called the SSA 6233, the Representative Payee Report. On it, the payee lists every dollar received during the reporting year, every dollar spent on the beneficiary's behalf, and the closing balance held in savings for that beneficiary as of the report date. The form is signed under penalty of perjury. It is the spine of the entire payee system. It exists for one reason. It exists because the people the system is designed to protect cannot read a bank statement. They cannot call a hotline. They cannot tell anyone the money is gone. The vulnerability in the system is not hidden. Anyone who has worked the disability field for a year understands it. The SSA does not, in the ordinary course, audit those annual forms against actual bank records. The agency reviews them for completeness, files them, and moves on. The forms are checked in detail only when something else triggers a referral. An adult protective services complaint, a police report, a family member who calls in. For a payee whose clients have no family, no police contact, and no one watching, the annual report is effectively a self-grade. Marlene Ashby had spent 20 years inside that system. She knew exactly how it was checked. More importantly, she knew exactly how it was not. By the spring of 2019, she had been appointed representative payee or court-ordered guardian for 31 disabled adults across Maricopa County. Several of them lived in group homes scattered between Mesa, Tempe, Apache Junction, and Gilbert. Several had no surviving family at all. No one noticed. No one checked. The mechanism Marlene Ashby built was simple, patient, and almost invisible from the outside. It ran for roughly 4 years, from the first quarter of 2019 to the summer of 2023. It began with the accounts. Federal regulations require that beneficiary funds be held in an account separately titled and clearly labeled as belonging to the beneficiary. Banks and credit unions are supposed to flag the accounts as such. In practice, regulators allowed payees handling multiple beneficiaries to use what is called a pooled account, with internal subledgers tracking which client owned which portion of the balance. The pooled account exception was designed to make life easier for small payees managing several clients at once. It was not designed for the small payee to be the only person with eyes on the ledger. Ashby Advocacy and Guardianship Services, LLC, maintained 2 pooled accounts at Desert Federal Credit Union on East Brown Road in Mesa, plus a business operating account at a different bank entirely. The Social Security checks for her 31 clients all flowed into the first pooled account on the 3rd of each month. The total monthly intake by mid-2020 was just under $32,000. Marlene paid the clients' rents on time. She paid their group home fees on time. She paid the small monthly stipends some of them were entitled to for personal spending money. None of the people she was stealing from ever went homeless, and not one of them ever missed a meal under her watch, because if any of them had, the entire arrangement would have collapsed in a single phone call. The minimum standard of care was the cover charge. What she kept was the surplus. Federal regulations state that any discretionary balance accumulated above the SSI resource limit must be saved in the beneficiary's name. For most of her clients, the discretionary balance was small in any given month. Maybe $200, maybe $300. For some clients with SSDI on top of SSI, it ran higher. Multiplied across 31 beneficiaries, it added up. Over 4 years, it added up to a number with 6 figures in front of it. She moved the money in 2 ways. The first way was a simple internal transfer. She would code an outgoing transaction from the pooled account as client expense reimbursement, billed to administrative, and route the money to the LLC operating account. The line items she invented were dry, bureaucratic, and difficult to question without a forensic accountant. Specialized housing placement, advocacy hours, guardianship administration fees, court appearance reimbursement. None of those line items matched any underlying receipt, but the SSA 6233 form did not ask for receipts. It asked for totals. The second way was bolder. She invoiced her own LLC for services rendered to specific clients, then paid those invoices out of the pooled account. The invoices were written on Ashby Advocacy letterhead. They referenced real clients. Several of them referenced services rendered to clients during periods when those clients were physically in a hospital and incapable of receiving any service at all. At least 2 of them referenced services rendered to clients who were deceased on the date of the alleged service, including one client who had died in December of 2021 and continued to be invoiced through April of 2022 for ongoing guardianship transition support. 4 separate clients were charged a flat $1,200 fee for specialized housing placement services that were never rendered. The fees were debited directly from those clients' benefit balances at the credit union. In the ledger she kept, the 4 debits were stamped with the same date, which happened to be the day she made a balloon payment on a leased Lincoln Navigator. She used the money to refinance the mortgage on a house in the Las Sendas community in Mesa, with a swimming pool and a view of the superstitions. She used the money for the Lincoln. She used the money for unremarkable retail purchases, mostly at Costco and at a department store at Superstition Springs Center, in amounts small enough never to trigger a review. The forensic accountants who later mapped the flows did not find a single offshore account, a single shell company, or a single dramatic purchase. There was no yacht. There was no gold. There was a comfortable upper-middle-class life in the East Valley, paid for, dollar for dollar, by the people the federal government had specifically named her to protect. The end did not start with a forensic accountant. It started with a paper towel. In late March of 2023, a young woman named Brittany Caldwell began a new job as the relief case manager at a 6-bed group home called Sonoran Pathways on a quiet street in West Mesa. She was 26 years old. She had a bachelor's degree in psychology from Northern Arizona University and a year and a half of experience at a different group home in Flagstaff. The Sonoran Pathways house manager handed her a binder of resident profiles on her first afternoon and told her to start with the man in room 3, a 47-year-old nonverbal resident named Theodore Larkin, whom everyone called Teddy. Teddy had moved to Sonoran Pathways in 2019. His parents were both dead. His older sister, who lived in Oregon, had signed off on Marlene Ashby as representative payee and guardian and had not been to Arizona in more than 4 years. Teddy received the full federal SSI benefit, plus a modest SSDI payment, based on a few years he had worked at a sheltered workshop in his 20s. Between the two checks, his monthly benefit income was just over $1,400. Brittany noticed 3 things in her first 2 weeks. Teddy's clothing was thin and worn at the cuffs, even though his benefit balance should have easily covered a quarterly clothing purchase. The house manager had been buying his toothpaste and paper towels out of the petty cash float because the guardian, she said, had stopped responding to the monthly supplies request. And when Brittany pulled the resident's personal needs ledger, the column meant to show his accumulated savings was blank. After 3 years in the home, full SSI benefits flowing every month, Teddy Larkin had $0 in personal savings. She asked the house manager about it. The house manager shrugged and said the advocate handled all of that. Brittany asked which advocate. The house manager pointed at a binder tab labeled in marker, Marlene Ashby, Guardian. Brittany wrote down the name. On April 11th, 2023, she filed a complaint with Arizona Adult Protective Services. The complaint was short. It alleged that a vulnerable adult in her care was going without basic necessities his benefits should easily have covered, and that his court-appointed guardian and federally appointed representative payee had been unresponsive to multiple requests from the group home. A PS opened a file. They assigned an investigator named Veronica Adesina. Adesina pulled the public guardianship record on Teddy Larkin, saw that the guardian was also the federal representative payee, and within 72 hours had referred the case to the Social Security Administration's Office of the Inspector General, the federal investigative arm with subpoena power over payee records. The OIG agent assigned to the case was a senior special agent named Daniel Rourke, based out of the Phoenix field office. He had been investigating payee fraud for 11 years. The day he opened the file, he requested every annual SSA 6233 form Marlene Ashby had filed for every beneficiary she had ever represented. The agency had them all on file. He took them home in 2 banker's boxes. She did not know any of this was happening. She continued to invoice. She continued to sweep. She continued, on the 3rd of every month, to receive 31 Social Security checks into a pooled account at Desert Federal Credit Union, and to move what she pleased to wherever she pleased. That was about to change. Before we get into the investigation, take a second to subscribe if this case has held your attention. We cover stories like this every single week, the ones where the safeguard turns out to be the predator. They do not get the coverage they deserve in mainstream news, and the victims very rarely have anyone speaking for them. That is what this channel does. Drop a comment with the city you're watching from too, because I want to see how far these stories travel. Special Agent Daniel Rourke worked the file for 4.5 months before any uniformed personnel walked into Ashby Advocacy and Guardianship services. The investigation moved slowly because Rourke knew exactly what kind of paperwork he was building toward, and he did not want a defense attorney to be able to point to a single missing subpoena. He started with the annual reports. By federal regulation, every representative payee must file an SSA 6233 form for every beneficiary every year. Marlene Ashby had 31 active beneficiaries at the time the complaint was filed, and had had as many as 34 at various points. Rourke pulled 4 years of reports. That was 126 individual forms, each signed under penalty of perjury, each handwritten by Marlene Ashby in the same careful, slightly forward-slanted print. The forms told one story. The numbers on them were clean, round. Each one showed thousands of dollars accumulating in savings for the named beneficiary, year after year. For Teddy Larkin alone, the 2022 report listed a closing balance of $14,800 in savings held for the beneficiary. Rourke then served a federal subpoena on Desert Federal Credit Union. The credit union turned over the underlying account records within 10 business days. The records told a different story. Teddy Larkin's subledger inside the pooled account, on the date of the 2022 report, held a balance of $43.18. Of the funds that had flowed through his subledger during the prior 12 months, investigators alleged that roughly $14,000 had been routed in 7 separate transfers to either the LLC operating account or directly to expense categories tied to Marlene Ashby's personal mortgage and her leased SUV. That pattern repeated across every client file. The reports showed savings. The accounts did not. The reports showed expense categories that read like legitimate caseworker activity. The accounts showed transfers within 24 to 72 hours of the SSI deposit hitting the pool, landing in places that had nothing to do with the beneficiary. A forensic accountant at the OIG, working under Rourke, mapped the 4-year flow. The total she identified, across all named beneficiaries, was approximately $280,000. The single largest victim was Teddy Larkin, with $41,000 in diverted funds over the 3 years he had been in her care. The second largest was a 42-year-old woman with profound intellectual disability, whose mother had died in 2020 and who had inherited approximately $26,500 from her mother's modest estate. That inheritance had been routed through the pooled account on its way to the LLC operating account and had never been returned. Rourke kept building. He pulled the LLC invoices. He cross-referenced the dates against the hospital admission records of the named clients, which he obtained through a separate administrative subpoena. He found, in the file of one client who had died in December of 2021, 4 billed advocacy invoices issued in 2022 for services rendered after the date of death. He found, in another file, 2 billed invoices for a client. During a week, the client had been an inpatient at Banner Desert Medical Center on a ventilator. The smoking gun was not any of the wire transfers. It was not any of the invoices. It was the SSA-6233 forms themselves. Marlene Ashby's own handwriting on a federal form, listing thousands of dollars in savings held for beneficiaries whose savings did not exist. The paperwork built to prove she was guarding their money was the paperwork that proved she had taken it. On August 21, 2023, a federal grand jury sitting in the District of Arizona returned a sealed indictment. The next morning, agents moved. At 7:46 a.m. on Tuesday, August 22, 2023, 2 unmarked vehicles pulled into the Strip Plaza parking lot on East Main Street in Mesa. Special Agent Daniel Rourke and a second OIG agent named Priscilla Tang stepped out of the lead vehicle. 2 agents from the FBI's Phoenix field office, present because of the wire fraud counts, followed in the second vehicle. They walked past the nail salon and the tax preparer and stopped at the glass door of Ashby Advocacy and Guardianship services. Marlene Ashby was already inside. She had arrived at 6:50, as she did every morning, with a coffee from a drive-through Dutch Bros on Power Road and a leather portfolio under her arm. The lights were on. She was at her desk on the phone with a group home administrator in Apache Junction, working out a transportation issue for a client's dental appointment. She saw the agents through the glass before they knocked. She told the administrator she had to go. Rourke entered first. He identified himself. He set a copy of the indictment and the search warrant on her desk and asked her to step away from the computer. Her face did not change. She stood up slowly, holding the phone receiver in one hand. She set it down in the cradle. She looked at the documents on her desk and then back at the agent. Marlene Ashby. What is this about? Special Agent. Rourke. Ma'am, we have a federal warrant for your arrest. The charges are listed in the indictment in front of you. We also have a warrant to search this office, your residence on Cliff Rose Drive, and the accounts at Desert Federal Credit Union. I need you to step away from the desk and place your hands where I can see them. Marlene Ashby. My clients depend on me. I have hearings this week. I have a court appearance Thursday for a guardianship review. You cannot just walk in here. Special Agent Rourke. Ma'am, your clients will be reassigned to a court-supervised public payee program. Step away from the desk. She stepped away. She did not raise her voice. She did not cry. Agent Tang began collecting the desktop computer and the file cabinet keys. Rourke stood across from Marlene with his hands resting easily at his belt. Marlene Ashby. You do not understand the pressure of this work. You do not understand what it costs to be the only person in the room for these people. I have given 20 years to clients no one else would touch. 20 years. Special Agent Rourke. Ma'am, that is something you can tell the court. Marlene Ashby. I want to talk to a lawyer. Those were the last words she spoke to anyone in that office. She was handcuffed at 7:53 a.m. and escorted to the lead vehicle in full view of the morning customers walking into the nail salon next door. By 8:30, she was in federal processing at the courthouse on West Washington Street in downtown Phoenix. The office on East Main Street was sealed by 10 that morning. By the end of the week, every one of her 31 clients had been notified, through their group home managers and through a court-appointed temporary fiduciary, that their guardian and representative payee was no longer Marlene Ashby. The federal indictment returned by the grand jury on August 21, 2023, charged Marlene Joyce Ashby with one count of theft of government funds under 18 U.S.C. Section 641, one count of wire fraud under 18 U.S.C. Section 1343, and one count of misuse of Social Security funds by a representative payee. The Maricopa County Attorney's Office filed a parallel state charge of exploitation of a vulnerable adult under Arizona's Vulnerable Adult Statute Framework, ARS. Section 13-1802 and Section 46-456. The state charge was later folded into the federal resolution. Her defense attorney was a Phoenix-based federal practitioner named Saul Brennerman, who had 30 years in the District of Arizona. Brennerman filed the standard motions. He moved to suppress the office computer on a technical warrant particularity argument. He moved to sever the state and federal counts. He moved for a competency evaluation, which Marlene herself refused to cooperate with. Every motion was denied. On November 19, 2024, Marlene Ashby appeared before United States District Judge Helena Quintero in the federal courthouse on West Washington Street in Phoenix. She pleaded guilty to one count of theft of government funds and one count of wire fraud. The remaining counts were dismissed pursuant to the plea agreement. Sentencing was set for the following March. The sentencing hearing on March 14, 2025, lasted just under 3 hours. 11 victim impact statements were entered into the record. Most were read by group home managers and case managers on behalf of clients who could not read them themselves. The statement that drew the longest silence in the courtroom was read by Brittany Caldwell, the relief case manager who had filed the original APS complaint on behalf of Teddy Larkin. Teddy cannot tell you what was taken from him, she read. He cannot tell you that the woman who sat next to him at his hearings, the woman who signed his Christmas card 3 years in a row, the woman he learned to wave at when she came into the house, was the same person draining the account that was supposed to make his future easier. He cannot tell you he understands that. I am not sure he ever will. But the rest of us understand it, and the court should understand that none of us will ever again hand a client to a stranger without checking. Judge Quintero delivered her sentencing statement from the bench. She spoke for nearly 8 minutes. The portion most often quoted afterward read as follows. Ms. Ashby, the role you held is one the federal government creates for one reason. It exists because the people in your care cannot protect themselves. Every safeguard in the representative payee system rests on the assumption that the payee will tell the truth on the annual form. You did not tell the truth. You wrote false numbers in your own hand, year after year, knowing the people whose money you were taking could not read what you had written. You understood the trust placed in you, and you understood the vulnerability of those who placed it. The court finds no genuine mitigation in your record beyond the absence of prior convictions. The sentence reflects the calculated and sustained nature of this offense. The court imposed a sentence of 51 months in federal prison, 3 years of supervised release, and $280,400 in restitution payable to the named victims and their assigned successor payees. A permanent bar was entered against Marlene Ashby, ever again serving as a representative payee, guardian, conservator, or fiduciary of any kind under federal or state law. She was remanded to the custody of the United States Marshals Service in the courtroom and transported within 90 days to Federal Correctional Institution Phoenix, a low-security facility on East Pima Road, north of the city. Her projected release date is in August of 2028. The 31 clients she had represented were reassigned to the Maricopa County Public Fiduciary Program, which now reviews their accounts quarterly against the underlying bank records. The accounts that had been closed were, where possible, reconstructed. Some balances were recovered. Teddy Larkin's account, as of the most recent public filing, holds just over $6,000 in his name. He still cannot read it. Someone else has to. This case was hard to sit with. The one waiting for you on the right-hand side of your screen is the one that kept me up the night I found it.